Today we're going to be talking about gun rights and how they intersect with the First Amendment. And we're joined remotely by Joseph Blocher as a professor of law at Duke Law School and the co-director of the Duke Center for Firearms Law. Joseph, welcome back to TalksOnLaw.
It's wonderful to be here, Joel. Thanks so much.
Let's talk about guns and free speech. How do gun rights and speech rights overlap?
I think just broadly speaking, one of the most difficult questions in constitutional law is figuring out what to do when rights overlap. Like, what do we do when one person's right to be free of discrimination intersects with another person's right to the free exercise of religion, which might include what would otherwise be discriminatory actions? Like, what do we do with when one person's right to free speech intersects with another person's right to privacy? And the same thing, I think we're seeing more and more with the intersection of gun rights and speech rights. And partly that's in effect just because of deregulation through constitutional law and through political choices. We're seeing more guns in more public places, that is, sort of guns coming into contact with people who might themselves be speakers. And that represents like a kind of a shift, I think, in gun law and policy. Like, the traditional frame has been that you got gun rights on one side, and then you've got like this kind of nebulous government interests on the other side. And I think what we're seeing more and more is that, no, this is like rights all around. It's constitutional rights and interests all around. And that's really hard.
Rights versus rights.
Rights versus rights, it's not a matter of just one individual asserting a right against the government. It's usually that the regulation being challenged is in place to protect other people's rights, including rights to safety and to freedom of assembly and to free speech and so on. And so that's really where I think we're seeing the hardest questions in gun law and policy.
Can guns or carrying guns actually be speech? Can my walking around with a rifle, can that be protected speech in and of itself?
It's a really interesting question. I mean, it kind of gets to the heart of really two, I guess, different ways to frame. One is like, in its just sort of general, before we even get to constitutional law, could we imagine that to be expressive conduct? And then second, if it is, does it trigger constitutional protection, right? So if we start with just kind of like generally speaking, like in a non-legal sense, I think most people intuitively think carrying a gun, especially in a public place, especially openly, expresses something. I mean, it might just express, leave me alone, I'm armed, all right, I'm dangerous. I mean, I think that's why many gun owners want to do it, is to deter a potential attacker. That is sending a message. And in that sense, it's expressive, right? I think just at a sort of general, how do we think about language and communication? I think it does communicate something. Now, that's not enough to trigger First Amendment coverage, because there's lots of things you can do that are expressive, which don't trigger protection as freedom of speech. Like if I punch somebody while I'm yelling at them, that punch sends a signal, right? It expresses something.
Very expressive.
It's very expressive, exactly, in a way they'll probably remember. But it doesn't count as protected speech, right? If I'm engaged in, securities fraud, talking to somebody else, that's communication, and it's expressive, but it doesn't count as freedom of speech.
But those are both crimes. I want to put that on the table. One is carrying a firearm, potentially peacefully. Another is punching someone or breaking a federal law.
I think that's exactly right, but that's really kind of the whole question, because what the Second Amendment does is put limits on what the government can make criminal. So if, for example, a person were to say, look, it's unconstitutional for North Carolina to have a law against open carry or brandishing, because that's limiting my ability to express to others, leave me alone, that's when the First Amendment, the Second Amendment would kick in, is putting limits on the things that can be made criminal. So, for example, if a state had a law that said you can't carry guns in public political protests because of the risk of danger, some people might come back, people have come back and say that violates my right to peaceable assembly, my right to free speech, and my right to keep and bear arms. So if we drill down on that free speech claim, like, is it expressive conduct for First Amendment purposes for a person to carry a gun openly in public? Generally, when the government is regulating for reasons unrelated to the message being sent, it's okay. So, for example, the government can't criminalize the burning of a draft card, to use a classic example, in order to punish the person for expressing their disagreement with the draft. But they can punish that person for littering or for arson, for things that don't have to do with the message being expressed, right?
Interesting.
So with guns, the tricky question is basically like, well, if the government's regulating to protect, say, public safety, it's not really trying to punish the gun owner for the message that he or she is expressing by carrying the gun, then it's probably not going to trigger First Amendment coverage at all. And that's the way that most courts have looked at it, is that, sure, this may be expressive in some sense. It certainly sends a message, but it's not expressive conduct for purposes of the First Amendment.
Is there a concern that bringing guns into this type of heated environment can, I guess, first off, be intimidating and limit others from exercising their free speech rights?
Yeah, I think that's absolutely true. And it's actually a really thorny question because the kind of intensity of the environment, the potential for harm, kind of cuts both ways. It raises the stakes on both sides. I mean, from a gun owner's perspective, that might be exactly why they want to carry a gun to a protest, right? Like, I feel endangered. That's why I want to have my gun, so that I can engage in, peaceable assembly or public protest or whatever. Like, that's what triggers the sort of need, the heightened need for the right. And also, that message may be intimidating, right? It may discourage other people from engaging in their constitutional rights and interests, like peaceable assembly or protest or counter-protest or speech or learning or worship or whatever else. And kind of, this is going back to the sort of rights versus rights conflict we were talking about. I mean, when those two things come into contact with one another, it's not enough to say, well, the gun owners are invoking their Second Amendment right or they're invoking their First Amendment right, because the fact is that it's the same interests being asserted on the other side: public safety, personal safety, and a right to freedom of expression. And it's worth noting that guns have been used to protect protesters as far as the Civil Rights Movement, right? Or before that. But they've also been used to intimidate, kill, and deter people from engaging in that kind of protest. So I don't think there's like an easy answer. I'd say too that this is another area where it's really hard to kind of measure the costs, and for that matter, the benefits. Like, some gun owners might say, I wouldn't go to this protest but for the fact that I can carry my gun, or I didn't go to that protest because I couldn't carry my gun. And that's hard to measure. It's also hard to measure on the other side, like how many people didn't go to, let's say, a protest or an assembly because they knew there would be guns there. Like, that's just a very hard to measure kind of thing. So even getting one's arms kind of around the stakes of the issue is really tough.
I guess this goes to another conversation that we've had, and I recommend it to the viewers to take a look on sensitive places. Could protests or certain First Amendment opportunities qualify for sensitive place restrictions?
It's really interesting you draw that connection, Joel, to the sensitive places discussion, because one of the things we talked about there is like how important it is today, after Bruen, to be able to point to historical predecessors of modern restrictions. So let's say a state today wanted to say no guns at public protests. Many states do have regulations like that. What is the sort of historical precursor to that? And in fact, there are a lot of historical gun laws. For example, many laws prohibited the carrying of guns in a way that consisted of going armed to the terror of the public, is the phrase, right? Like, maybe that maps on to the kind of situation that you're describing there. Again, as we talked about in our sensitive places discussion, there are lots of gun laws that are focused on exactly these places of what my colleague Darrell Miller has called constitutional conflict, whether it's, polling places, legislative assemblies, places where kind of democracy happens and where, guns for that reason might be subject to kind of heightened regulation. I would say armed groups, like armed private militia, have generally been subject to broad restrictions and in some sense prohibition, and that continues today. Those kinds of laws have fared very well under the Second Amendment and the First Amendment. That is, most courts have generally upheld them. Now, again, the Bruen decision from the summer of 2022 imposes a new sort of methodology for evaluating them, but at least thus far, they've tended to be upheld. I guess another thing I'd say here is that you can imagine from the perspective of a gun owner, the argument being made that, look, guns at public protests, let's say, are actually not only not sensitive places, they should be doubly protected because they involve the simultaneous exercise of two constitutional rights, the right to keep and bear arms and the right to free speech, or the right to, peaceable assembly, if you like. And you can imagine how that kind of arithmetic there kind of sounds appealing. But again, I don't think it works quite so well. There's a great article that Professor Michael Dorf of Cornell Law School wrote called When Two Rights Make a Wrong, arguing against this. And one of the things that Professor Dorf points out is that, again, you may have two constitutional rights which can't be exercised in conjunction, or that if you tried to exercise them in conjunction, you have to, kind of choose one or the other, like engaging in political speech and voting. You can't do both those things at the same time. That's what laws against electioneering are all about. So the math doesn't quite work that way.
When we look at the First Amendment and the Second Amendment in terms of constitutional treatment, the First Amendment has quite a bit more evolved doctrines. When we're now evaluating the Second Amendment, should courts, or are courts, drawing on that First Amendment free speech doctrine and then use that to inform Second Amendment doctrine?
And the answer to this is courts can do it, and some already are doing it. And the question really is kind of when and how is that sort of constitutional borrowing appropriate? My former colleague, Jake Charles, now teaches at Pepperdine Law School, has written a fantastic article on this issue of borrowing between the First and Second Amendments. And I think it kind of starts with the sort of basic proposition that sometimes courts take doctrines that evolved in one area of law and kind of move them over to another. So, questions of what we today call scrutiny that evolved really in the equal protection space and move over to, say, due process or whatever. So there's nothing, I don't think, like in a broad level, kind of wrong with doing that. The real question is, are the two contexts kind of relevantly similar such that the borrowing makes sense? Because it's not always going to make sense to take a test from one area and put it over in another. So one example for the First and the Second Amendments is for free speech. There are certain doctrines that are just kind of unique to free speech. They don't apply in any other areas of constitutional law. One is the First Amendment basically prohibits what are called prior restraints. So the government can't generally keep speech from happening, even if it could punish you afterwards for that speech. So the idea here is we would rather the speech just happen. We don't want to overly chill people from engaging in the speech conduct because at the end, a person can be sued or criminally punished or whatever, right? But that doctrine of prior restraint doesn't work for any other area. You don't get that for free exercise of religion claims or due process or equal protection or whatever. Some gun rights advocates have made the argument, well, prior restraints should apply to the Second Amendment. You shouldn't have to get a permit, for example, to carry a gun. That's a prior restraint. It should be unconstitutional. And I think courts have said, and I think rightly in this context, no, that's not. Prior restraints is just about speech. You don't get to import that one over. And that's been universally, as far as I know, rejected. But there are other doctrines from the First Amendment which kind of do make sense, maybe, for the Second Amendment. So one is, in the free speech context, the government has some leeway to regulate the time, place, and manner of speech, as long as in doing so, it's sort of neutral with regard to the message that's being expressed, and so long as there's sort of like the regulation itself is reasonable. So I think some people say, well, that actually could help explain regulations on like things we've been talking about, like carrying guns at a public protest, right? Like at that spot, time, place, and manner, you may not be able to carry your gun, even if you can have it in your home for self-defense, or maybe carry it in some other kind of public areas. So, again, like importing one to the other, you just have to start with like, are these two contexts relevantly similar? And that's a broad challenge we're seeing in lots of other areas of Second Amendment law, kind of figuring out how to do that analogical reasoning.
Well, wait a second, Professor. Does that mean that you're only seeing space to import First Amendment doctrine into the Second Amendment where it helps the state to regulate?
No, no, and I'm glad you asked, Joel. So just to be clear, the time, place, and manner test, for example, would rule out, as it does for free speech, it would rule out some forms of government regulation, including, for example, a citywide ban on handguns, or maybe a ban on carrying guns into any public or populated place. Those tests should have bite. I mean, the right to keep and bear arms is and will remain, I think, in doctrine, a fundamental constitutional right that's subject to various forms of protection. Sometimes that borrowing will help beef up the Second Amendment's protection, but sometimes it's doing all right already by itself. The test that the court articulated in Bruen, which is the test of text, history, and tradition that you and I have talked about, is in many ways already more stringent than the tests the court applies to free speech. So maybe that gun rights are actually better off not borrowing some of these tests and kind of sticking with what the court's given them in Bruen.
Joseph Blocher is a professor of law at Duke Law School and always welcome here at Talks on Law. Professor Blocher, thanks so much for your time.
Thanks again for having me, Joel. I look forward to the next one.